For recording purposes, my name is Paul Moite, appearing for the petition. His Excellency Brigadier Gachagua, in petition E565 of 2024, in which he is the petitioner. And I do so, my lords, your leadership, with my learned friends, Senior Counsel Elisha Ongoya, Tom Macharia,
Present, my lord.
Swanya Victor Ogeto, Faye Waigwa, John Jomo,
Present. Present.
Ochi Dudley, you want me to use this? Ochio Dudley, and finally Willis Echesa. My lords, your leadership, given the large number of parties and their respective counsel, with your concurrence, my suggestion is that counsel appearing for the different parties introduce themselves for the sake of arguments. I thank you.
My lords and my lady, I was waiting for the second petitioner, but in the matter for the third petitioner, my name is Muge, and I appear together with my colleague, Uncle Jen Jerry Minor. Jen Jerry Minor.
Good morning, your lordships, your ladyship. For the 4th to the 8th petitioners, my name is Ogada. I appear with my brother Sakimpa. Thank you.
Good morning, my ladies, my lord. My name is Wanjiru. I hold brief for Mr. Kibe Mungai. We appear together with Kibe Mungai for the 10th to the 41 petitioner, together with Mr. Ole Kamwaro, Mr. Nyamu, and Mr. Simon Boro. Equally well, my lady, my lord, for the 44th to 49th petitioners, the quorum remains as stated.
Your lordship, my lady, my name is Morala Omoke, 43rd petitioner and counsel, and petitioner in D027 of 2024. I appear personally.
You are which petitioner?
I am the 43rd petitioner, your lordship.
Once more, permit me to also place my senior Mr. Maanzo on the quorum for the 44th, 45th, 7th, 8th, 49th petitions.
Present, my lord.
I'm instructed by the Honorable Attorney General to appear on our behalf and I am here with my learned junior, Mr. Christopher Marwa. Present. With your permission, I have taken the liberty of introducing everybody appearing for this meeting. I have my learned friend, Mr. Gumo, Mr. Yamodi, and Mr. Kuruma appearing for the National Assembly. I have my learned friends, Professor Thomas Jenda, Senior Counsel, and Mr. Mukele appearing for the Senate. I have my learned friend, Dr. Mukele Fiampolo, Senior Counsel, appearing alongside Moses Kipkogei, Ken Melly, Kenson Motadia, Boniface Maura, and Steve Ogola for the Honorable Professor Kidiki, the second sorry, I am corrected there. The Honorable Professor Kidiki, the second interested party. And I am advised that there is Mr. Bore for the first and eighth respondents, and that should come out as well. And the interested party. Thank you. Appears for the Senate, and he is my
You said his name?
Thank you.
My lords, my name is Michael Mushemi. I am here together with Paul Kubula for the 9th respondent. I'm also requested to introduce Mr. Hira, who holds brief for Dr. Kamoto for the 10th respondent.
Is that all for quorum?
That appears to complete the appearances. May I proceed?
Thank you very much for attending the forum. There's some preliminary issues we want to address before we proceed. The first point is to
we were not able to get the ceremonial hall where we could have been much more relaxed than we are in this place, because the ceremonial hall is being used for other purposes. That is also a promise that we made. We are not able to keep it, therefore we apologize for that. To ameliorate the issue, we have created an overflow courtroom, that is court number 325, where there's a screen, and therefore you can inform others who may want to hear that there's an overflow courtroom number 325. The second direction we want to make is that we had selected 3 days for the hearing of this petition. That is today, tomorrow, and the day after tomorrow. But for reasons our ability, we are not able to proceed tomorrow or the day after tomorrow. This is so because one of us here, Justice Murima, is a member of the Judicial Service Commission, and they are carrying out interviews for the Supreme Court. That is an assignment which he cannot avoid. And therefore, we will adjourn after today. We wanted to let you have this information well in advance so that you are aware even as you argue the petition. For that reason, we have decided, and we hope that you will accept this decision because getting a date is very, very difficult, that the second hearing will take place on 7th of May, and the third hearing will take place on 8th of May, all starting at 10 a.m. The last direction concerns petition number 586 of 2024. Is Councillor Pinyanji in the house? Mr. Pinyanji?
Yes, my lord, I'm online.
All right.
I was informed that it would be hybrid. I appear for the petitioner. I'm present.
Yes, we will mention your matter, this petition number 586 of 2024 at 4 p.m. today.
At 4 p.m. today?
Yes.
Thank you very much.
Thank you. I think we are now ready to go.
May I seek a small clarification in respect of today, up to what time in the morning section does the court intend to sit? In other words, when do we break for lunch? When do we come back? If we break for lunch at all, we are in your lordship's hands.
I think it would be prudent for us to break at 1 and come back at 2.
Thank you.
Yes. Senior Counsel Paul Goethe, we would like to know how many will be addressing us so that we allocate time.
For the 8 counsel appearing for the petitioner, the first petitioner, my lords, your ladyship, bearing in mind that the first petitioner is the subject of the impeachment, the main pleader in these proceedings, we have divided the highlighting of the submissions amongst the 8 of us. Perhaps my learned friend, senior counsel Elisha Ngoya and myself will take a little longer than the others. But the plea I'm making with what I'm saying is to plead with the court to bear in mind that this is the first opportunity petitioner, first petitioner, is having for stating his case. I plead that he be given adequate time. Thank you.
So what are you proposing?
I am proposing, in other words, my lords, that you kindly allocate me 1 hour give or take, and Elisha Ngoya 2 hours give or take, and the others 30 minutes give or take. That will be adequate for us. In fact, this Honorable Court had indicated when we last appeared before the court that we would have to dig for the petitioner's case. And because there are many petitioners, I was just saying the person most affected is the first.
My lord and my lady, on our part, the third petitioner would request to be given 1 hour.
If it may please the court, the money for the petitioner will just take 20 minutes to let us finish.
Your Lordships, between myself and my brother Sakimpa, we'll equally need 1 hour.
Even as we get those solutions, bear in mind that the day has so many
We endeavor to make it shorter.
All right. I think we will proceed on the basis that we'll give you as much time as humanly possible within a day.
We agree. Hello? May I start, Your Honor?
Yes.
My lords, your ladyship, the court will recollect that when we last appeared before this noble court on the 24th of February 2025, I stated to this noble court on record, on behalf of His Excellency regarding Gachagua, that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency regarding Gachagua amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish, again, my lords, your leadership, to reiterate that position on record. My lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the question, if this court agrees with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law, plus damages. Finally, for the period of 2.5 years that His Excellency Rigathi Gachagua served as the second Deputy President of the Republic of Kenya. It is our submission that Article 151 of the Constitution is fully applicable, and I invite your Lordship and your leadership to have a look at that Article 151 when you retire. Briefly, my Lord, impeachment cannot and could not have been retrospective. That is the submission. Lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his father amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October 2024. Number 2, his bundle of authorities and case digest, dated 7th of October 2025. And number 3, the first petitioner's written submissions, dated 7th October 2025, which submissions are the ones we are highlighting today before this noble court. My Lords, paragraph 1 to 19 my colleague is drawing my attention that we also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April 2026. Thank you. My Lords, your leadership, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this honorable court, when it retires, to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this honorable court's attention to paragraph 5, which you will find at page 7 of our written submissions. My Lord, page 7 of our written submission, paragraph 5, is what I'm briefly referring to. The National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However, the exercise was not adequate or meaningful. The exercise did not provide the public, for example, with the deputy president's side of the story. The public was only presented with the allegations made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the deputy president was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757 to 758. And also exhibit marked RG 7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go, that the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this report to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. Lord, if you look at paragraph 8, 9, and 10 and 11, and they appear from page 8 of our written submissions. Paragraph 8, my Lord, you see, the respondent, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider, and I pause here to emphasize the word plenary, you know, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution and the Standing Order, it was not open to the Senate to bypass the Committee of the Senate, where the law gives the Deputy President the first petition the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced as scheduled on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination. In this Honorable Court, you'll be taken through all that, my learned friends here. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President of the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of the 11 counts. And you find all that in RG 11, volume 9, pages 1689 to 1725, response by Brigadier Gachagua. And also RG 12, volume 9, pages 1752 to 1758, communication from Nigeria. Now, the third matter I wish to very quickly draw the court's attention to in this introduction background is the absolute failure for both the National Assembly and the Senate to address their minds to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems of government. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the Prime Minister. There are many examples of parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our constitution that members of the National Assembly can vote and christen their resolution that there are breaches of the constitution, and you will be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the constitution. That is not what is permitted in our constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. An impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the song called Moving Gideon Kioko and another versus Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I say, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. My Lord, if you go to page 11 of our written submissions, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submissions as the issues we suggest that this honorable court should address in determining this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the deputy president to be addressed by each one of us. My Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed by different countries. My Lord, the issues I want to address in those issues listed in paragraph 17 are 1, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the deputy president a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the deputy president was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2010 Constitution. And the third one is whether the overnight clearances for the replacement deputy president evidenced a predetermined process compounded by the violations was that, whether that was unconstitutional. My Lord, your leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, which is the motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional order. My Lord, your leadership, my learned friend Gachagua here, and myself had the privilege of arguing the Wambora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution or other written law. They didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wambora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterate will apply to the impeachment of the president himself. It's very weighty issue that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as the Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, Ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law warranting his removal from office by impeaching the Deputy President on the basis of a section that had been nullified by this court. What he didn't know was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of impeachment. And my Lord, you find that authority, paragraph 62, allied case, pages 62 to 63. And although Article 145(1)(b) only applies where there are serious reasons for believing that the Deputy President has committed a crime, in Ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Ladyship, the Senate voted on that impeachment charge on the basis of a repealed section. You find that in Exhibit RG3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in Ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security agent. My Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, sub-article 5, is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is Cap 206 of the laws of Kenya. You will find in Part 3, Civilian Authorities, the heading, Effective Civilian Authority. They then say that the Cabinet Secretary will be the civilian authority oversight. The Cabinet Secretary is part of the executive. That is not civilian oversight. Simply put, this National Intelligence Act has never complied with the provisions of the Constitution. Had they operationalized that and set up a civilian oversight authority, it is that civilian oversight authority that would take up these issues. But criticism, despite the freedom of thought and expression in our Constitution, the first petitioner was still convicted for criticizing the NIS director. So, my Lord, Your Ladyship, what you are submitting here is that there was absolutely no attempt by the National Assembly, by the Senate, to address their minds to the high standard of gross violation of the Constitution. My Lord, Ground 5 accused the Deputy President of grossly violating Article 3(1) and 148(5)(d) of the Constitution and of failing to uphold his oath of office and allegiance. There were no details provided. Instead, Ground 5 simply referenced Ground 1, 2, 3, and 4. This unfair and confusing charge was such that even though the Senate cleared the Deputy President of Ground 2 and 3, it still voted to impeach him based on Ground 5. There was no attempt to explain, even vaguely, how the Deputy President had violated his oath of office. Ground 6 equally alleged that there were serious reasons to believe that Brigadier Gachagua had committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why wasn't he taken first to the National Cohesion for prosecution before invoking the last resort remedy of impeachment? Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent, irrefutable, factual, and legal response to each of the 11 grounds cited in the impeachment motion. Lord, you see that in Exhibit RG2, Volume 2, pages 211 to 240. For instance, concerning the claim in Ground 8 that the Deputy President had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering, the Deputy President explained that no valuation had been done, so where the National Assembly, Honorable Mwengi Mutuse, got 5.2 billion is anybody's guess. If you want to charge somebody, you present them that this is the value of this property. Further, from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother, the late Honorable James Derito Gachagua. May his soul rest in eternal peace. Some, like the Olive Garden Hotel, Vipingo Beach Resort, Queensgate Serviced Apartment, he did not even own. And yet, this was what he was impeached on. But we are falsely attributed to him. He produced ownership document showing otherwise, and you will find that, my lords, in RG2, volume 2, pages 211 to 214. Lords, although the mover of the motion listed that the two companies associating them with the petitioner, first petitioner, alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption, and benefit from influence peddling, there was not a scintilla of evidence to support or prove those allegations. No evidence showed any impropriety, and you'll find that in RG2, volume 2, pages 214 to 218. The Speaker of the National Assembly, again, a good professional colleague who I respect, did not direct the members to the threshold test, the appropriate standard. Hence, the resolution was passed in proceedings conducted as a vote of no confidence rather than a critical step in impeachment proceedings to alter the sovereign will of the people. And you'll find that as message of the Senate, number 025 of 2024, approval of special motion, RG3, volume 6, 745 to 745. Equally, the National Assembly's decision of 8 October 2024 was invalid on the grounds that, one, the impeachment motion was replete with the general unsupported allegations, hearsay, and outright lies, and lacked particularization and specificity required by Article 145(1) of the Constitution of Kenya and Standing Order 64(1)(a) of the Standing Orders of the National Assembly. 2, members of Parliament debated and voted on the motions on grounds other than those set out in the motion. The impeachment was converted into a vicarious assault on family rather than investigation of constitutional violations by a public servant. Members of Parliament, let me skip that and go through the next one. The entire impeachment process was designed to avoid and be ring-fenced from scrutiny and accountability, pushed through with uncharacteristic speed, with the intention of ramming the process through before it could be audited for constitutional compliance. The National Assembly prosecuted proceedings on the basis that the petitioner offended the president rather than the Constitution. What the 2010 Constitution provides is violation of the Constitution. In other words, the president must take time and choose his deputy. My Lord, I don't need to take time to go through what the country was put through between His Excellency Daniel Toroitich Arap Moi and his Vice President George Saitoti dangling the Vice Presidency, requiring the President to choose his or her deputy before the election so that the people could themselves vote is a very important aspect of our Constitution. The National Assembly trivialized the gross misconduct standard set out by the Constitution and other statutes for holding public servants to account. And, my Lord, I will not repeat the Wambora case, but I would state the impeachment motion was replete with generalized statements, unsupported allegations, hearsay, outright lies, lack of particularization and specificity as required by Article 145. My Lord, the exposition on all that is set out in paragraph 36 of our written submissions, and I will not take the time of this court going through them. I invite the court to read through it when you retire. Despite this clearing and fatal flaws apparent on the face of the motion, even on a cursory review, soon after the impeachment motion was tabled in the National Assembly, the first respondent issued a communication from the chair, number 46 of 2024, in which at paragraph 16, 18, and 20, he stated that he was satisfied that all the grounds in the impeachment motion met the requirements of the threshold under the Wambora case. The first respondent legally incorrect decision to allow the motion to proceed for debate, despite its clear failure to meet the specificity and accuracy requirements of the standing orders, seems to have been motivated by Parliament's bias and reckless haste to pass the motion as quickly as possible in order to shield the process and its obvious serious rules from judicial review. It is our submission that that was the real reason for the rush. My Lords, Article 50, Sub-Article 2B of the Constitution states that every accused person has the right to a fair trial, which includes the right to be informed of the charge with sufficient detail to answer, to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that evidence. The motion thus violated Article 50, Sub-Article 2B, and Article 50, Sub-Article 2J of the Constitution by setting out vague allegations, criminal conduct, including the Deputy President had violated and repute sections of the penal code, the leadership and integrity without ever charging it. Overall, the impeachment motion of the first respondent's communication from the chair was thus incapable of invoking the National Assembly's mandate under Article 150 as read with Article 145. In other words, you will see all that in RG 1, Volume 1, pages 2 to 41, and RG 8, Volume 7, page 969 to 976. So, my lord, that is all I wish to say about A. Let me very quickly move to C. My lord, issue C is there a problem with your gadget? Say, hold on. I'm listening to the gadget. My lord, issue C is whether the Senate.
Do I need to remind you about time?
Only another 10, 15 minutes.
You have barely 5 minutes.
Yes. Moving as quickly as I can. See, my lord, which you find at page 40 of our submission, is whether the Senate misled by its misinterpretation of Article 145, rushed the process and denied the deputy president hearing. The Senate, my lord, recognizes the right to a fair hearing in considering a petition for removal of a person from office because they say so in their standing order number 81, the right to appear before the committee, the relevant committee. That is in standing order number 81. Whenever the Constitution or any other written law require the Senate to consider a petition for a proposal for the removal of a person from office, the person shall, and the word used in standing order number 81 is that the person shall be entitled to appear before the relevant committee of the Senate. The petitioner here was denied that opportunity to appear before the committee. And the importance of the committee, my lord, is that the committee has got less members. The law gives the subcommittee 10 days to investigate. And therefore, the deputy president would have been able to appear before that subcommittee with his evidence, with his lawyers, and would have been able to argue. By bypassing the setting up of that committee and assuming that the 10 days related to the plenary, which they did not, the deputy president was denied a fair trial. My lord, when the deputy president had all along appeared in person and signaled his willingness to take the stand, he became new. And none of us, all of us are human beings. My lord, illness does not come knocking. One is just taken ill. And he was taken ill after very stressful, strenuous proceedings, National Assembly, and the first day in the Senate. Lord, it's a very stressful situation for the deputy president to be deprived of that position to which he had been elected by over 7 million people. Lord, when counsel for the deputy president stated that he had been taken ill, the speaker ruled of the Senate, I said we were going to execute with military precision owing to the fact that we need to conclude business today. And he said I had indicated that I could not get hold of the client or the doctor's advice because he had been admitted to ICU. First, the 10 days did not apply to the Senate. That was a misreading of the Constitution in the law. But secondly, there was time we were requesting adjournment up to Tuesday to see about the deputy president improvement. But the speaker said they could only adjourn up to Saturday. His proposal for adjournment to Saturday was shut down by the senators voting and saying they would not allow adjournment even to the following. And no reasons were given for rejection of an adjournment to the following day, Sunday. Lord, this was a serious violation of the rules of natural justice. Lord, adjournment by the Senate is discretionary, but like all discretionary power, the discretion is to be exercised objectively, judiciously, and upon reason, not arbitrarily, capriciously, or on whims. Here, falling ill on the second day of a grueling 2-day hearing, the Deputy President sought a 3-working day adjournment to Tuesday, 22nd October, to enable him to recover and appear for cross-examination. The Senate defeated that proposal to adjourn until Saturday to see if the Deputy President had recovered. Egged on by the National Assembly, the Senate insisted on proceeding in the Deputy President's absence. My Lord, you will see at paragraph 83 of our written submission the case of the then Major General Peter Kariuki versus Attorney General. It is number 3. It is paragraph 3, page 250 in our banner, where the Court of Appeals said the appellant's request for a 3-working day adjournment, 3 days adjournment, to instruct counsel was denied. He had been held incommunicado without access to a lawyer for over 147 days. He had less than 10 hours in total, and in a prison setting to instruct his lawyer to prepare his defense. Overturning the court-martial decision denying the adjournment, the Court of Appeal explained, it must never be forgotten that the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. We are of the opinion that although the same principles are relevant in respect of application for adjournment of criminal trials, nevertheless, because of the constitutional basis of that right, the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for the adjournment and to specifically consider whether denial of such a right guaranteed by the Constitution would result in miscarriage of justice. There are very many cases cited, even in the common law. My Lord, again, I had the privilege of arguing this case before the court martial back in 1983, following the attempted coup, and also through the High Court, through the Court of Appeal. The conviction by the court martial was quashed on the basis that Major General Kariuki, the commander of the Air Force, had been denied a fair trial. My Lord, in the interest of time, I was going to highlight the speed with which the whole process from the word-go all the way through was done, but including the rest of it. But I invite the court to read our written submission. I only mention that after hearing the Deputy President on the 8th of March, finishing at about 8 p.m. Anyway, on the date that the National Assembly considered this motion, they voted to impeach close to 9 p.m. The normal working hours are daylight hours. How is it that the National Assembly could not even wait for the following day to transmit their resolution to the Senate? Lord, it was transmitted at night. And the following day, the Senate set the date to commence the proceedings. Equally, when the Senate, after depriving the Deputy President a fair opportunity to defend himself, impeached on 5 out of the 11 grounds. Equally, they had to transmit the impeachment resolution back to the Senate close to midnight on the same night. In other words, I'm inviting this court to see this breakneck speed. Somehow, the Speaker of the National Assembly had in advance issued a notice convening a sitting of the National Assembly. On a Friday, which is not a normal sitting day. Any thinking person will wonder how the Speaker of the National Assembly, a good friend of mine, senior counsel, how was he able to anticipate the likely decision of the Senate in advance? And above all, although the resolution of the Senate was being transmitted back to the National Assembly after midnight, between midnight and the following day, His Excellency the President had time during the night to get clearance for the person he wanted as his Deputy President from the Ethics and Anti-Corruption, from KRA, from the Electoral Commission. These are public institutions. In fact, the Electoral Commission did not even have commissioners to make a decision clearing the choice of the Deputy President. But I mention this to demonstrate the unholy rush. I invite this court to see through the smoke screen cotton thrown about by the National Assembly and the Senate to confuse issues. They were merely saying we have the numbers. There was no attempt to address serious violation of the Constitution. Lord, I hand over
to
Okay.
Thank you, my lords and my lady. My name is Elisha Ongoya. Number one, I have reflected on a number of unjust trials in human history. The trial of Sir Thomas More, the trial of Socrates, and even the trial of Jesus Christ. One element characterizes these trials. When you read history, there are trials that are carried out with predetermined outcomes. Those who are taken through the trials are taken through the motions for the sake of it. My learned friend, Mr. Wachira Maina, whom I've had the chance to work with, reminds me all the time that behind every constitution lies a moral idea and a moral expectation that there will be good faith compliance with the commands of that constitution. In fact, Mr. Wachira Maina informs me, and I believe him, that in management theory, there is a concept described as malicious compliance. It informs me that there is a legitimacy gap that is wider than the Pacific Ocean between good faith compliance and malicious compliance. I want to persuade you that the motions that the first petitioner was taken through at the National Assembly and the Senate of Kenya passed the test of malicious compliance. The danger of allowing malicious compliance to go unredressed is that it injects an irredeemable legitimacy gap in constitutional processes. The second inspiration that I wish my lords to bear in mind as you determine this matter was set out by the Court of Appeal of Kenya in the case of Martin Nyaga Wambora and 3 others versus the Speaker of the Senate and 6 others. This matter traversed our entire superior court system. I'll therefore be very emphatic of which particular court I'm referring to when I refer to the Wambora case. So I'm looking at the Court of Appeal 2014. In that matter, the Court of Appeal began by setting out what would inspire it as it writes that judgment. So you look at paragraphs 2 and paragraph 3 of the 2014 Wambora case at the Court of Appeal. The Court of Appeal observes, and I quote, "No parliament, no official, and no institution is immune from judicial scrutiny." I say this because to such other debt as you shall defer us to, some people will take this stand and tell you that there are political issues here that are immune from your scrutiny. The second inspiration that the Court of Appeal set out in the Wambora case was that it is the Constitution, not Parliament, not the executive, not the judiciary, which is supreme. It is the Constitution. I stand here to canvass one substantive question, a continuation of the threshold concerns surrounding the motion, particularly as eventually approved by the Senate. Your brother, Mr. Justice Bahati Mwamuye, has observed in the now famous Kawira Mwangaza case that watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. That's the big risk that our constitutional order is subjected to if we allow what happened in this country, culminating into the resolution of the 17th of October 2024, to stand. It's a threat to confidence in our constitutional democracy itself. Allow me just to reiterate one question that has bothered me, and my learned senior colleague, Senior Counsel Paul Mwita, has touched on it. On 17th of October 2024, when you go through the Hansards of the Senate that I will draw your attention to in a short while, the Speaker of the Senate delivered a communication from the chair, an actual ruling, which informed the members that the first petitioner was in fact indisposed and not available to be heard as guaranteed by law. My lords will agree with me. It requires extremely compelling reasons to insist on proceeding with a case where the subject of that trial is indisposed. It must be exceptionally compelling reasons, not just reasons. When you deliver this judgment, because this matter, I've had the misfortune of sitting on the front benches of this case from the time this matter of the National Assembly to the present. This question has disturbed me as a role player in the justice, law and order sector. That the Senate of Kenya, even after the Speaker erroneously, and I use the word erroneously, advisedly, because my learned colleague, Mr. Dudley, will take you through the timelines for impeachment in Article 145, as read that one, but even after the Speaker erroneously said, we have a timeline of Saturday. They had no such timeline, but the Speaker said so. The senators voted to deny the Deputy President the benefit of those 2 or 3 more days without giving any reason. I would want to read in your judgments, my lord and my lady, through what logic this court will allow that decision to stand, if no other decision, that particular one. That for no reason, we are not saying the heavens will come down falling. We are not saying the country will be subject to any external attack. We are not saying there is any constitutional imperative that compels us to do it tonight. No reason. They simply said, we will not give you the benefit of those 2 days that the Speaker has said we still have. Let's go on record. The Speaker too was wrong. But there may have been some veneer of good faith. If they had said it's okay, because we have 2 days, let us give him the 2 days for whatever it is worth. They said, even that, we are not going to give it to him. On the threshold questions, the matters that I'm specifically tasked to bring to your lordship's, ladyship's attention are the following. Number one, Article 150, Clause 1 of the Constitution sets out the constitutional textual threshold for removal of a deputy president from office by impeachment. And it says is on the grounds of gross violation of a provision of the Constitution or any other laws. Secondly, it says is on the ground of serious reasons to believe that the deputy president has committed a crime under national or international law. Serious reasons. I'll be making out a simple case that the National Assembly really disappointed the country. To approve a motion that there are serious reasons to believe that the deputy president has violated a provision of the law, Section 132 of the Penal Code, which has been declared unconstitutional, null and void, is a locus classicus of lack of seriousness in the reasons. And thirdly, the standard of gross misconduct. Let's face it, my lords, my lady. The drafters of this constitution could as well characterize these wrongs as violation of the constitution, because that's also a wrong, or reason to believe that the DP has committed a crime, or misconduct. Those are wrongs. But they were particular to add these descriptive words, gross, to the violation, gross to the misconduct, and serious to the reasons. The conclusion I draw from this is that they set a very high threshold for removal of a deputy president from office. Our courts have followed cue. I will start with the Supreme Court, sample 2 decisions there, go to the Court of Appeal, sample 1 decision there, then go to the High Court and sample 1 decision there. From the Supreme Court, the decision of Sonko versus the County Assembly of Nairobi City and 11 others. Yes, we do. Yes, we do. Correct. Okay. I'm highlighting, my lord, so I was avoiding reading them. So I'm drawing simply because if I have to take you through the pages, then it means I have to actually take you through the submission themselves. I'm just highlighting salient aspects of those submissions so that we save on time. Thank you. So that in Sonko versus the County Assembly of Nairobi City, I beseech this court to look at paragraph 161 of that judgment. The Supreme Court observed that the grounds for impeachment and removal from the office must be substantiated. The grounds for impeachment and removal from office must be substantiated. It means, my lords and my lady, the motion mover and his supporting cast of witnesses must show us where is the supporting evidence for each of those grounds. They must show where the supporting evidence is. Because substantiation simply means adduction of adequate evidence to lend credence to the ground. The Supreme Court then sets the standard as what has now been called the intermediate standard. Not so low as to be on a balance of probabilities, and not so high as to be beyond reasonable doubt. You will find these descriptive words of grounds for removal from office in removal of other office bearers from office under our constitution, like judges of superior courts. They'll be removed on similar grounds. And you'll see the Supreme Court has dealt with that in the case of Muya versus the tribunal appointed to investigate the conduct of Justice Martin Mati Muya, Judge of the High Court. In that matter, the Supreme Court now attempts to give us the meaning of the word gross. And you'll find that at paragraph 181 of that judgment of the Supreme Court. And it says, and I quote, clearly, all the words used to describe gross express some extreme negative conduct. Not just negative conduct. It says extreme negative conduct. And it proceeds to say a degree of misconduct of such a serious, outrageous, and flagrant nature that would warrant removal of a judge from office. That is how serious it ought to be. Those are the words of the Supreme Court. So, the Court of Appeal, I have already observed, set that standard in the Martin Nyaga Wambora and 3 others. I'll just refer you to paragraphs 42 through 45 of that judgment. But there is something else that I want us to draw from the Martin Nyaga Wambora case. How to frame charges for an impeachment motion. Because the Court of Appeal also dealt with that question. And when you look at paragraph 44 of the Martin Nyaga Wambora decision, the 2014 Court of Appeal decision, that's the one I have in mind. If you look at paragraph 44, you will see that the Court of Appeal draws similarities in drawing charges for an impeachment motion to drawing criminal trial charges for court. In fact, the court uses an example of how to draw a charge of robbery with violence in trying to explain how specific a charge for impeachment should be. I say this because in drawing criminal trial charges, there is a wrong in framing charges called multiplicity of charges, and I'll show you how that wrong applied in the trial of His Excellency Rigathi Gachagua. Then finally, for the High Court jurisprudence, I will refer you to the High Court decision in Honorable Mike Sonko Mbuvi, Gideon, and Okia Omtata versus the Clerk, Nairobi City County Assembly. These were 2 consolidated petitions. And I will draw your attention to paragraphs 257 through 259 of that judgment of the High Court. For ease of reference, I will refer you to the various aspects of the impeachment motion that is in volume number 1 of the petitioner's document, from pages 1 to 209. Look at that volume. And I'll refer you to the Hansard proceedings of the Senate. You'll find the Hansard proceedings of the Senate in the documents filed by Mukele Moni advocates in the CTS that are labeled Parts 5 and Part 6. Part 5 and Part 6. In Part 5, you'll find the Hansard of 16th October 2024. Then in Part 6, you will find a continuation of the Hansard of 16th October 2024 and the Hansard of 17th October 2024. That Hansard is also referred to in the affidavit of my very good friend Jeremiah Nyegenye as Annexure JN 10 at paragraph 31 of that affidavit, which was sworn on 21st October 2024. So, returning to the question under scrutiny from my end, I would invite you to look at page 59 of the Hansard of 16th October 2024. This is now the page of the Hansard itself, not the page of the bundle, because my learned colleague, Mr. Mukele, did not paginate the full bundle. So you look at the page of the Hansard itself. Something very interesting happened. I want to paint the picture so that I abridge on time. Before the trial of His Excellency Gachagua at the Senate issued a trial schedule, a schedule of the proceedings. The National Assembly had given the Senate a list of 5 witnesses. His Excellency, the Deputy President, had submitted his affidavit alone as his own witness. So the DP side had 1 witness, being the DP only. The National Assembly presented 5 witnesses. When the schedule came, the schedule gave the DP's team 2 hours to cross-examine the 5 witnesses of the National Assembly and 3 hours to lead the evidence in chief of the Deputy President. The Deputy President's team took the view that it did not need 3 hours to take their witness in exam in chief. This is their own case. They suggested to the Speaker that we need these 3 hours for our exam in chief and perhaps the 3 hours for our cross-examination of the National Assembly witnesses and perhaps the 2 hours for our exam in chief. So we are not taking any more time of the Senate. We're just reordering our own time, the one you have given us. At page 59 of the Hansard of 16th October 2024, the Speaker dismissed that literally by way of the hand. I mentioned three significant trials that have shown me that when these kind of things happen, it means there is malicious compliance. We are simply going through the motions. No one is asking for the Senate any more time. We're just saying of the time you have allocated us, we have a lot more duty in cross-examination. Give us more time towards that. We have lesser duty in exam in chief. From our own time, give us less time on that. It is judicially noticeable that the Speaker of the Senate is a lawyer of many years standing. It cannot be that he didn't understand the injustice inherent in the disproportionality in that time allocation. It cannot be he didn't understand. He understood it by virtue of the trust bestowed upon him as a trained lawyer. He breached that trust. Allow me to then very briefly take you through the various grounds of impeachment as set out in the motion and the evidence, what the evidence revealed in respect of each of those grounds. I would start with the ground number 4 of the impeachment motion. The particulars of that ground will be found at paragraph 34 of the motion itself. The particulars of ground number 4 will be found at paragraph 34 of the impeachment motion. This is one of the grounds that the Senate approved and which contributed to the loss of office of His Excellency Rigathi Gachagua. The particulars state that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. It is a requirement in impeachment proceedings that the impeaching house cannot introduce any new grounds at the Senate stage. They are held to account on the grounds as approved by the National Assembly. The ground was that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. So a number of things are important, my lords, my lady. One, what does Article 160, Clause 5 of the Constitution provide? It provides that a member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. It's not liable in suit. You can't take them to court. If you look at ground number 4 and particulars of paragraph 34, it is alleging that the threat to take a judge to the Judicial Service Commission is a violation of Article 160, Clause 5. I wonder, their lawyers are here, they will tell us. In fact, some senators are actually here, they will tell us. How does Senate read Article 160, Clause 5 as against Article 168, Clause 2? Because Article 168, Clause 2 constitutionally gives any person the right to initiate a petition before the Judicial Service Commission for the removal of a judge. So if you state that you are going to pursue an Article 168, Clause 2 process, how can that be a violation of Article 160, Clause 5? I was taught many years ago, I hope it's still learning today, the Constitution is not self-annihilating. We cannot read Article 160, Clause 5 to destroy Article 168, Clause 2. So that the National Assembly brought a case to the Senate that a claim by the Deputy President that he is going to file a petition against Justice Esther Maina is a violation of Article 160, Clause 5. The Senate approved that ground for removal of the Deputy President. Now, let's not lose focus of this, my lords. The express text of the ground and the particulars at paragraph 34 of the motion is that the Deputy President had falsely threatened to file a petition against Justice Maina. Now, the Supreme Court has told us the ground must be substantiated. So I will now take you how the motion mover substantiated the ground. If you look at page 60 of the Hansard of 16th October 2024, so on the attached the affidavit of Jeremiah Nyegenye as Annex J N10, the following conversation takes place. The motion mover is being cross-examined by yours truly. The Hansard of the Senate captures me as asking this question: do you still stand by that part of your allegation that he has not presented the complaint to the Judicial Service Commission as at that date? The motion mover says, I have since learned that he did present the petition. The motion mover is conceding that he's claiming the motion that the Deputy President falsely threatened to file the petition cannot pass muster. Yours truly, my lords, then suggests to him that to the extent that you say that he has not presented the allegation to the JSC as at 26th September 2024, that allegation is not true. Is it? The motion mover says, we are in agreement, counsel. The motion mover concedes that the ground on which his motion is founded, ground 4, cannot be substantiated. With this Hansard before them, members of the Senate voted to approve this ground. Can it be said that in view of this concession by the motion mover, that ground had been substantiated, that it passed the threshold? The third aspect I want my lords to reflect on when you retire, you can answer this question either way. Some of us enjoy reading these judgments either way. But I want direct answers to these questions. A judge has had a case and delivered a judgment and become functus officio. Can a verbal criticism of the manner in which that judge conducted herself in that case constitute a violation of the decisional independence of the judge? That's what the ground said. It said gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. Can a verbal criticism of a judge, because of a decision she has already rendered and become functus officio, amount to a threat to the decisional independence of that judge? Which decision? She has already rendered the decision. I submit to my lords that it is actually good democratic practice to subject judicial decisions to heightened scrutiny. It is good practice. It grows judicial accountability. And therefore, what the Senate did by approving this ground was a clawback on an important democratic practice of enhancing judicial accountability. The two grounds that I want to deal simultaneously are grounds 5 and 6, because they suffer the same fate of inadequacy. Grounds 5 and 6. Ground 5, and both of them were approved. So I've already dealt with one that was approved. I'm dealing with two others. Then I'll deal with two others to finish the 5 that were approved. Ground 5 accused the Deputy President of gross violation of Articles 3.1 and 148.5a of the Constitution and fidelity to the oath of office and allegiance. Then ground 6 provided that the deputy president, that there were serious reasons to believe that the deputy president had committed a crime under sections 13(1)(a) and 62 of the National Cohesion and Integration Act. Those were the two grounds. So, a ground must be supported by particulars. That's what the Supreme Court has said. Then the particulars must be substantiated. Now, when you look at the motion, ground 5 had no particulars of its own. Ground 6 had no particulars of its own. Instead, what the drafter of this motion, in his drafting wisdom, did was to say the grounds in support of ground 5, the particulars in support of ground 5 are the particulars in grounds 1, 2, 3, and 4. That's what he said. Similarly, in respect of ground 6, the drafter didn't supply particulars. Instead, he said the particulars in support of ground 6 are the grounds set out in the particulars set out in grounds 1, 2, 3, and 4. My lords, as experienced jurists, you know better than I do that particulars are the specific acts or omissions constituting the wrongdoing. The specific acts or omissions constituting the wrongdoing. The National Assembly went to the Senate and said, we are charging the Deputy President in ground 5 and ground 6 because of the acts and omissions we have referred to in grounds 1, 2, 3, and 4. Is that a permissible way of framing a charge of impeachment? I began by setting out that it has been established that the grounds, the charges in impeachment are framed in the same manner as charges in a criminal case. This court, the High Court rather, has held in 3 different cases. The case of BMK versus Republic, 2020 EKLR. The case of LKO versus Republic, 2022 EKLR. And the case of Etiang versus Republic, 2022 EKLR. I'll just refer to one because they make the same principle. Justice Ongudi said, and I quote, "The problem I find in the charge sheet is one of multiplicity of charges." Then she defines multiplicity. Multiplicity in a charge sheet arises from charging of a single criminal act as multiple separate counts. This may result in violation of the right of an accused person under Article 50, Clause 2, Paragraph O of the Constitution. That multiplicity of charges is a violation or a threat to Article 50, Clause 2, Paragraph O. And it defines multiplicity to mean charging a single act as multiple separate counts. So therefore, when the National Assembly tells us that the acts in ground 1, 2, 3, 4 are the same acts that constitute the ground 5 and ground 6, these 2 grounds were bad for multiplicity. They were a violation of Article 50 of the Constitution. They cannot found a threshold for impeachment. Both of the 2 grounds were approved by the Senate as constituting the basis for removal of the Deputy President from office. But there's something very bad about it. The Senate voted to approve grounds 5 and 6 on the particulars set out in 1, 2, 3, and 4, and ground 5 on the particulars set out in grounds 1, 2, 3, and 4, but acquitted the Deputy President of grounds 2 and 3. And remember, they gave no reasons for convicting. And that's how obscene this trial in plenary is, as my learned colleague, Mr. Chel Dudley, will take you through in a short while. Then finally, ground 1. Ground 1 accused the Deputy President of gross violation of Articles 10(2)(a), B, and C, 73(1)(a) and 2B, 75(1) and C, so 75(1)(c) and 129(2) of the Constitution, and Articles 47(1) as read together with Articles 131(2)(c) and D of the Constitution. In summary, my lords, these were the grounds that accused the Deputy President of talking about shares in government and shareholding in government. Let me just paraphrase it like that. That's in summary what this is about. My learned colleague, Mr. Tom Masharia, took the motion mover through cross-examination on this ground. You will find that at pages 88 to 94 of the Hansard of 16th October 2024. So a number of things emerged. I just summarize them. Number 1, the motion mover confirmed that the government of the day in Kenya is formed by a coalition of parties named the Kenya Kwanza Coalition. Motion mover confirmed that as a fact. Number 2, he confirmed that the Kenya Kwanza Coalition was formed of pre-election coalition agreements involving various parties. Number 3, among the parties were UDA, ANC, Ford Kenya, and PAA or PA, as is sometimes called. And my lord, this must come out very succinctly from me. It bears that PA is the party whose party leader was the Speaker of the Senate presiding over these proceedings. When you finally take time to read pages 88 to 94, the motion mover confirmed that each of these coalition agreements made references to sharing of government. And they expressly spoke about sharing government positions and sharing resources. You'll see the coalition agreement between Ford Kenya and ANC talking about certain roads in Western Kenya, nowhere else. You will see the coalition agreement with the PA talking about development of marine resources in coastal Kenya. You will see positions, the leader of Ford Kenya being promised the position of the Speaker of the National Assembly and certain cabinet portfolios and principal secretary portfolios. The leader of the party called PA being promised a position of the Speaker of the Senate. The question, therefore, is that when parties enter coalition agreements and pre-election manifestos, it is the people who determine whether they want to be associated with that kind of manifesto or that kind of pre-election arrangement at an election. For some reason, the people of Kenya chose this agreement with shareholding arrangements in 2022. If the people of Kenya are unhappy, they have another opportunity in 2027 to deal with it. And that is exactly what the High Court set out in the Sonko decision that I have just referred to. If you look at the High Court Sonko decision at paragraph 258, the High Court says an impeachment is an important remedy, but one of last resort. It is one to be used where there is an injury to the people. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed came to office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. If the people of Kenya had gone to the 2022 elections on the strength of these pre-election arrangements that talked about shareholding, it follows that they had a chance to revisit that question at the next election cycle. That's what the High Court is telling us. But, my lords, the more interesting one for me is at page 95 of the Hansard of 16th October 2024. You'll find the following very interesting conversation between Counsel Tom Macharia and the motion mover, Ecomas Mwenge Mutuse. I'll briefly take through the conversation, my lord, but you will take note of the pages and revisit it when you retire to do duty of writing judgment. Tom Macharia begins by playing a video to the motion mover and posed the question, who is speaking in that video? The motion mover, Mwenge Mutuse, responds, the President of the Republic of Kenya, Honorable William Ruto. Tom Macharia then poses the question, which words did he use? What did he say to the people of Murang'a? Mwenge Mutuse says, he has appointed many of the locals into his government. Tom Macharia prods further, did he say, nyinyi watu wa Murang'a ni shareholders wakubwa wa hii serikali? Mwenge Mutuse says, yes, he did. The people of Kenya have no difficulty waiting to assess their president at the next election cycle in 2027 following this conversation. The question we want you to deal with is this. Why is the president's reference to the people of Murang'a as shareholders in his government acceptable political rhetoric? And a similar reference to the people of Nandi and Kericho, because those are the areas mentioned in the motion, by his deputy, an impeachable offense. It's worth noting that when you read the conversations I've told you at pages 88 to 94, you will find that the person who witnessed the pre-election pacts in Kenya Kwanza was Professor Kithure Kindiki, and despite witnessing agreements with the shareholding model in it, the National Assembly had no difficulty approving it now to become the deputy president. It is that uneven-handedness that we want this court to ask itself this question. Did the National Assembly find a wrong, then sought to establish who is the wrongdoer to be punished, then found the deputy president? Or did it find the deputy president then asked, what wrong can we put on him to punish him? Which is what appears to me to have transpired in this set of circumstances. I have taken you through the 5 grounds that were approved by the Senate to demonstrate to you that they were bad for multiplicity. That's grounds 5 and 6. They fell short of the threshold as set out in Article 150 of the Constitution, as expanded upon through judicial interpretation. And therefore, generally, they could not found a motion for removal of the deputy president from office. While principally, therefore, beseeching this court to allow this petition, allow me now to invite my learned colleague, Mr. Chell Dudley, to take you through the reading of the constitutional prescription on the impeachment procedure and how the interpretation of those provisions by the Speaker of the Senate fell way off the mark. Mr. Dudley, you're welcome. Thank you, my lord.
Thank you. Thank you, my lord, for the opportunity to address you on this important question. When we last left the court, I had thought that we were done with jurisdiction, but the National Assembly spends the first 32 pages of their submissions saying that you either lack jurisdiction, or if you have it, then you're limited to looking at the process. And you should not hear the substantive violations that my 2 colleagues have told you about. They cite, quite helpfully to us, a Filipino case, Francisco versus House of Representatives, where the Filipino Parliament had similarly argued that the Filipino judiciary had no jurisdiction to review impeachment proceedings. The court concluded that that process has procedural safeguards, and therefore it answers to a legal process. My lord, that stance, the stance that the proceedings you're dealing with are both political and legal, is found in the report of the Technical Working Group D on the executive. My senior counsel, team leader, Paul Mwito, was a delegate number 114. The current speaker was delegate number 209 at the CKRC conference. And you'll hear Professor Githu Muigai, when he rises, tell you that these provisions on impeachment were hotly contested. They were the most contentious provisions. And so, my lord, detail was paid to these provisions. The law is that Parliament does not waste words. Every word in a legislation must be given a meaning. Now, let me begin with what's common ground. On 9th October 2024, JN4, the affidavit of Jeremiah Nyegenye at paragraph 22, the morning sitting, in the Hansard, the Speaker of the Senate misleads the Senate, saying that we have 2 options to deal with this motion, alike the procedure for governors and deputy governors. He says we have a motion is the first for impeachment of deputy president, but we have 2 options that we have when it comes to the impeachment of deputy governors and governors. My lord, that is a heresy. And because of that, just common ground again, the Senate does not form the committee. The special committee under Article 145(3) is not formed. Why? The Speaker
misleads the House that they have two options. They can either investigate the charges by committee, Article 145.3a, or they can investigate by plenary, like they do for governors. My Lord, I request that my Lords be given our rejoinder submissions, table 1, because I intend to spend a moment or two there. My Lord, the Senate picks the 10-day timeline applicable to the special committee. Remember, they've dropped the committee. They've said, no, we have two options. We are investigating it in plenary. But they retain the 10-day timeline applicable to that special committee. And so, when the Deputy President falls ill, my colleagues have addressed this, the Speaker holds on to the 10-day deadline applicable to the special committee for a plenary hearing. And the members of the Senate vote to deny the Deputy President even the benefit of that 10 days, the balance of it. They say we must conclude our business today. In doing that, the Senate grossly violated the Constitution. My Lord, let me bring your attention to Table 1. In Table 1, we've tabulated the differences between Article 145.3, Senate Standing Order 78 and 80, and Rule 2, Rules of Procedure for removal of the Deputy President by impeachment and governors. My Lord, Article 145.3 does not give two options. It gives one option, and it says that within 7 days after receiving notice of the National Assembly resolution, the Senate Speaker shall convene a meeting of the Senate to hear charges against the President. And the Senate, by resolution, may appoint a special committee comprising 11 of its members to investigate the matter. The special committee has a constitutional function. It investigates the charges for seriousness. Then it reports to the Senate. My Lord, there's a may which seems problematic here, but we'll tell you where that may originated. But as it is, it makes grammatical sense. The Senate must convene within 7 days, and if the Senate convenes in 7 days and the motion is approved, there's something worthy of investigation here, the Senate may appoint the committee. It must not appoint the committee always. Why? Because sometimes you'll find that it's flimsy. The charge is that the Deputy President, the President, wore a yellow shirt. He should have worn green. Or he wore a blue shirt when he should have worn a red one. Flimsy charges. My Lord, the test on threshold has already been laid to you. So literally, grammatically, Article 145.3a has an and. If you go to 143.5b and you begin with the Senate, by resolution, may appoint a special committee comprising 11 of its members to investigate the matter, and you leave the A, what have you done to the and? And is disjunctive. It means you must bring both elements of the law together. Parliament does not waste words. Every word used by Parliament in a law has meaning. And the court must give each word in the law meaning, especially if that law is a constitution. My Lord, staying with Table 1, Standing Order 78, which is a provision applicable to the President, reflects faithfully the wording in Article 145.3, word for word. Then, this is where the original sin happens. Standing Order 80, and that is on page 2 of our Table 1. I really hope that my Lords have it so that we take this argument, because it's a technical one and it's on the details. But when you come to Standing Order 80, which is the procedure applicable to governors and deputy governors, it allows the Senate to investigate in plenary. Standing Order 81 says, within 7 days after receiving the resolution, the Speaker of the Senate shall convene a meeting of the Senate to hear charges against the governor. And the Senate may, 1, by resolution, appoint a special committee comprising 11 of its members to investigate the matter, or investigate the matter in plenary. The Speaker imports this "or" in Standing Order 80, brings it to Standing Order 78, replaces the "and" there. The Senate shall convene and may by resolution appoint a committee. He replaces that "and," he deletes it. He uses "or." So he tells the senators you have two options. You can go investigate this by special committee, or you can investigate it by plenary, like we do for governors. My Lord, if you look at the constitutional article for impeachment of governors, you will not find the kind of detail that you have in Article 145. Why? My learned friend, my senior Professor Guido, will tell you that this Article 145 was intensely debated. It was one of the most contentious provisions in the history of the making of the Constitution. So it comes complete with detail. But the Speaker here replaces the word "or" in Standing Order 80 and takes it to Standing Order 78 to Article 145(3). He deletes "and" implants "or." What misled the Speaker could be is Rule 2. My Lord, that's the last item, number 4, on page 2 of our Table 1. Rule 2, Rules of Procedure, also makes the same mistake. It replaces the legislative word "and" in Article 145 with the "or," disjunctive. My Lord, Rule 2 says the Senate may in plenary investigate the matter and determine whether the particulars of the allegations against the President have been substantiated. It has now omitted. The special committee is gone. So Rule 2 goes to 145(3) and then descends to B by plenary. It's saying the Senate may investigate by plenary. Where did this error originate in the making of our Constitution? My Lord, I go to that because if, suppose we are not making sense and our argument is too full of grammar, the theory of holistic interpretation requires you to look at the text, which we have done, and the history. What was the history? And how did we end up with a provision that, quote unquote, could sound difficult? My Lord, the theory of holistic interpretation is mainstreamed as a theory of interpreting our Constitution. Let us then travel back in time to the Bomas Conference. But my Lord, before I do that, allow me to draw your attention to a fresh new publication of the Senate. And that is a digest of the law and practice on removal of county governors and deputy county governors from office through impeachment. First edition, brand new, published last year. I apologize, I haven't yet produced it to the court. I intend to do that, but it's also available online, thanks to the Senate. My Lord, the Senate worries about this process. It says committee vis-a-vis plenary proceedings. And the Senate, this is about governance. It says that the law does not provide for any specific procedure. Page 104, a case digest. You do not have it yet. I've just apologized that I came across it yesterday because it's a new publication, but I will put it on record. When you turn to it and you look at page 104, you find that the Senate says that the law does not provide for any specific procedure. As a result, the county assemblies and the Senate are not bound to follow any route. That is what informs the rules of procedure, where the Senate may investigate. And that is also what informs Standing Order 80, where the Senate may use plenary to investigate. But, my lord, the Senate recognizes what this court has in Sonko High Court. This court said that we are of the considered view that impeachment of a governor is a serious undertaking. The impeachment of a deputy president, of a president, is a more serious undertaking. For this reason, we recommend that it will be desirable in future impeachments to proceed through the committee route as opposed to the plenary. This High Court has recognized the inherent risks in investigating through plenary. Why? We say so because when the special committee is appointed, the Article 145(3)(a) committee, it has 10 days to deliberate on the matter, thus giving many opportunities to the parties to prepare their cases adequately. The committee gives the perception that each member is actually engaging in the process as opposed to the plenary, which can be perceived to be a mob lynching process. That's exactly what happened here. The investigation in plenary was a mob lynching process. The Senate goes on to say that trial by the committee, page 105, a case digest on removal of governors and deputy governors, a publication of the Senate, brand new 2025 bond. Trial by committee gives the Senate, through the 11 members, an opportunity to review the usually voluminous documents from the governor's team. A trial by committee over the 10 days would have given the Senate the time to review.
As a request, we clarify the record while my colleague is addressing that point. In his written submissions, that decision is describing, it is described as a decision of the Supreme Court, but it is actually a decision of the High Court. So that we don't have to later belabor this point now that we're addressing it. Can he confirm? Because the written record says it is a decision of the Supreme Court, but it's actually a decision of the High Court.
I'm grateful that my learned friend, Mr. Mudomi Thiankul, a very good friend of mine, felt compelled to interrupt at this point, indicating its importance. It's an easy one. The decision is High Court Sonko. There's a typo saying it's Supreme Court. It's High Court, but it's what the court has said. Now here, at page 105 where I was, the Senate is speaking to a member of staff of the Senate involved in this process. That's what this report highlights there. And this member of staff, I hope it's my learned friend Ms. Tanji, is saying that trial by committee, the special committee under Article 145(3)(a), gives members and would have given the deputy president's team enough time to interact with the senators on the voluminous record. Because of the fewer members, the committee is able to probe and follow up with specific questions, especially where the grounds for impeachment are technical. Perhaps the committee would have caught out that in Robert Alai, a case I was fortunate to argue with my learned friend Mr. Ongoya, the court had already nullified section 132 of the Penal Code on undermining the authority of a public officer. Well, this did not happen in this case. And finally, it records here that the plenary, it also says that there are some benefits to the plenary report as well. My lord, in short, what you are saying is that the motion to impeach the deputy president was contingent on the special committee's report. It's not just procedural. There's also a substantive right given to him before that committee. Look at Article 145(5) of the Constitution. The deputy president has a right to be heard before that committee. the committee investigating the serious charges leveled against him. That step was omitted. That's a grave violation of the Constitution. My Lord, the final chance that he had to be heard was also denied to him, the adjournment. When something like that happened, in a case that my friend, Professor Ojenda, Senior Counsel, argued with his usual merit, Onyango Law versus Kisumu County Assembly, Service Board, 2025 Kenya Court of Appeal, 333. The Court of Appeal was persuaded that Onyango Law had been denied a fair hearing. And just like in Oloma Law, the Senate here speedily approved the motion, skipped that special committee altogether, but retained the 10-day timeline. I wonder what the 10-day timeline was doing in a plenary setting where the Constitution does not impose that 10-day timeline, but requires reasonableness. It obviously can't delay until the end of the term, but that 10-day timeline was a stranger in the process. And so the Court of Appeal was persuaded that Onyango Law was unfairly impeached. My Lord, we ask you to take the Onyango Law decision and...
I don't like interrupting things at all. But just out of Onyango Law was given 1 hour. The Deputy President had 10 days.
My Lord, whereas the special committee would have had the President, the Deputy President over 10 days, he was investigated in plenary over 24 hours and impeached in his absence. So I ask you again to take the Onyango Law decision, and where it says Onyango Law, please substitute Rigathi Gachagua and make your decision. My Lord, let me take you to the drafting history of our Article 145. It was not initially there as Article 145. And my Lord, the theory of holistic interpretation requires you to consider our social, our political, our historical context as a people. That history has names like Oginga Odinga, mistreated by the President, unfairly removed from office. It has Kungu Karumba, George Saitoti, at some point, not appointed at all, reappointed after the elections. I forget which year, I was a young boy then. But in your ruling of 31st October 2024, my Lord, you recognize this history, and you said that the Vice President served entirely at the President's mercy. That was a framework that the 2010 Constitution sought to transform. And under the 2010 Constitution, the office of the Deputy President is fundamentally redefined. Your words? It was safeguarded from arbitrary and capricious actions by the President. Before the Senate, on 16th October 2024, another good friend, Senior Counsel Otiende Amolo, a former member of the Committee of Experts, who was familiar with the drafting history of Article 145, reflected as follows, and I quote, "Before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes." So my example of the color of his coat was not so far-fetched. It is on the Hansard record. My Lord, that's a correct reflection on the intention, on the history, on the motivations, on the framing of Article 145. In the National Land Commission versus Attorney General Supreme Court advisory opinion, the court held that unlike the independence constitution that failed to articulate the history and struggles of the people, the 2010 Constitution integrates that history and the people's view. And so, my Lord, when you turn to interpret Article 145, and you encounter the challenge with the may appearing in the second part of it, in 135 3B, and you wonder why does it appear this way? You must remember the history. Speaking of history, at page 182 of the CKFC final report, and that, my lord, is the lawyer's Bible, is the constitutional lawyer's Bible. It is the reference point for ambiguous text. We go back to it to see what was the intention here, what was the struggle, what was the mischief. The people said that, I quote, there should be adequate mechanisms to avoid the risk of impeachment being used for purely political motives. Page 802 of that CKFC final report records that impeachment was one of the most contentious issues leading to extreme polarization amongst delegates. And the issue was not about the desirability of impeachment. No, it was about the procedure. What procedure do we use? Because we agree that the president must be amenable to impeachment. It is a remedy of last resort. But what procedure do we use? My lord, in the Bomas draft that came out of that conference, the CKFC proceeding, we had Article 164. Article 164 of the Bomas draft is the exact replica of today's Article 145, except it had a bit more clarity. Why? Because the kind of Thank you, my lord. My lord, because the kind of contestations that attend the making of any constitution had not been there. Remember, by the time we are getting to 145, we've gone through a failed referendum. We've had the WACO draft. We've also had the Naivasha process that messes up and moves articles around. So back in Bomas, Article 164, this is what 164.4 said. If a motion is passed under Clause 3, Clause 3, the Speaker of the Senate is considering what has come from the National Assembly. The Senate shall appoint 13 of its members as a special committee in accordance with the standing orders to investigate the matter. So this committee was there, 164.4 Bomas draft. The special committee shall investigate the matter, 164.5 Bomas draft, and shall within 10 days. So the 10 days is also there. It's not a new invention under 145. 164 Bomas draft had it. And the president shall have the right to appear and be represented before the committee. So this right also to be heard before the committee was also there. 164 Bomas draft. My lord, we then had the Guy draft, 163. This clause appeared at Article 163 of the Guy draft. And it also said that if a motion is passed under Clause 2, the Speaker shall constitute a special committee comprising the Chief Justice and 13 members of the National Council. So even when this committee was thought the Chief Justice should sit on it, it was there. When the name changed to National Council, the committee was there. It has consistently been there. Article 163.5 of the Guy draft provided that the president would have the right to appear and be represented before the special committee. So when it was Article 163.5 and not 145.5, the deputy president's right to appear was there. I take you next to 2009 harmonized draft constitution by the Committee of Experts. My lord, 163.4 of the Guy draft also required the committee to investigate. So its function was there. Its composition changed a little bit, but the entitlement to appear before this committee and to be heard during the investigation of the charges was consistent. Article 170, 2009 harmonized draft. Now we are getting closer to the referendum. 173, upon hearing the charges under Clause 2, Article 173, 2009 harmonized draft, upon hearing the charges under Clause 2, the charges approved in the motion that has come from the National Assembly, the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter. So the number is now at 11. And the special committee shall investigate the matter within 10 days and report to the Senate whether it finds the particulars of the allegations against the President to have been substantiated. The President, you can guess, shall have the right to appear and be represented before the special committee during its investigations. My Lord, now we go to Naivasha. A constitution is a political charter. It will have vagueness of phraseology. Why? Because you need to get consensus and have the document passed, or you have no constitution at all. And so we take it as it comes, with ambiguity. But that's not the kind of ambiguity that scares this court. The court would be adept to interpret the Constitution together with those ambiguities, understanding its history. Now, ambiguity is coming in. Naivasha, the Parliamentary Select Committee, a committee of politicians, they move this clause to Article 127.3. And they're saying, upon hearing the charges under Clause 2, the National Assembly, now, you know, they're also shifting it from the Senate. They're bringing it to the National Assembly, Naivasha. The National Assembly may, by resolution, appoint a select committee comprising 11 of its members to investigate the matter. My Lord, from 127.3, Naivasha, it gets back to 145, and it brings with it the main, which is there today. That's how it sounds vague. That's why it appears ambiguous. My Lord, throughout that history, the 10-day period is there. I am concluding, my Lord. The function of the committee, it's okay, my Lord. The function of the committee is also there. And the Deputy President's right to appear before it is there. And so, when on 9th October 2024, the Speaker misleads the House, telling it that you have two options, what is the source of that authority? Where does the Speaker get the right to amend the Constitution in his directions to senators? What gives him the right? It's not even the standing orders. My Lord, he fuses, the Speaker fuses Standing Order 78, Standing Order 80, the Rules of Procedure, and Article 145. And in that process, Article 145 suffers violence.
Just clarify, you said that it appears ambiguous.
Yes.
Is it ambiguous?
It is not ambiguous. If you look at its history, if you look at its intention, if you consider that constitution making, Speaker of the Senate versus Attorney General, is a political process, it is quite clear. The Senate may appoint that committee if it finds that there's something to be investigated. My Lord, blue shoes, nothing to investigate. What's the committee to investigate? But if there's something that appears plausible, there's something that needs some kind of investigation, then the Senate must appoint that committee. So the may turns to must. It must only appoint if there's something to be investigated. If it concludes that there's nothing to be investigated, the malicious and malicious compliance, if there's nothing to be investigated, it doesn't need to appoint the committee. My Lord, let me move forward and say that in Speaker of the Senate, the Supreme Court explains precisely this kind of phenomenon, where the document born out of long-drawn negotiations, 2002 when I was a schooler to 2010 when I joined the university. Long drawn process. The document is looked at, touched by many hands, including a number represented before the bar today. Constitution making requires compromise, which can occasionally lead to this kind of contradictions, where you have a shall in 145.3a and the may in 145.3b, and to those who are mischievous, it appears to be ambiguous. My Lord, political and social demands of compromise that mark constitutional moments fertilize vagueness in phraseology and draftsmanship. And when there's such, where do we turn? We turn to the court. And we ask you to interpret Article 145.3, considering the history I've laid out. Constitution making does not end with promulgation, it continues with interpretation. It is the duty of the court to illuminate legal penumbras that constitutions born out of long-drawn compromises such as ours tend to create. My Lord, the spirit of the Constitution has to be invoked by the court as a searchlight for illumination and elimination of these legal penumbras. My Lord, if this clause was so contentiously debated and nearly cost us the Constitution, how is it that the drafters could have intended that Senate can investigate these serious charges in plenary without saying so? How can such a serious provision be left to inference by a technical interpretation of the word may, that because it says may, that's discretionary? What about the and before the may? My Lord, how could the drafters have intended that Senate could investigate in plenary within 24 hours, even denying the subject of the impeachment a fair hearing? I turn to an issue of comparative constitutionalism. My Lord, no other country has a similar kind of fast-track impeachment that can be done in 24 hours. No other democratic country, at least according to my research. South Africa has the panel at Article 89 of its constitution. We call it special committee. South Africa calls it independent panel. The role of that independent panel, Section 89 South African Constitution, is to determine if sufficient evidence exists of a serious constitutional violation before the National Assembly votes. The role of this special committee was to sieve off some of these things that we are now confronting you with. Section 132 Penal Code, nullified. How can it form an impeachment charge? United States uses the House Judiciary Committee to investigate the charges. My Lord, in Nigeria, Article 143.5 of the Nigerian Constitution, there's a panel of 7 members appointed by the Chief Justice of persons of unquestionable integrity, but who are not politicians or civil servants for independence. Panel of 7 appointed by the Chief Justice. If my learned friend, Professor Ogenda, were not a senator, but were a Nigerian citizen, he would sit definitely on this panel. In Philippines, Article 11, Section 3, that it's called the Committee on Justice, this special committee. In South Korea, Article 65, the committee is called the Legislation and Judiciary Committee. It investigates the charges after a motion is proposed, though the Constitutional Court ultimately will adjudicate the trial. In India, Article 61, it's called Investigating House Committee. My Lord, the long and short of it is that what we had here was not a constitutional process that is worthy of this court's protection. If you faithfully interpret Article 145, if you just have one look at Standing Order 78, at Standing Order 80, if you look at the rules of procedure, Rule 2, and then you spend time, my Lord, with the history of Article 145, you will arrive at one inevitable conclusion. That is a conclusion that failing to appoint the special committee required by Article 145(3), my Lord, grossly violated the Constitution. And that violation was not harmless. It bogged the Senate down into a fictitious timeline. It said we are not appointing the committee, we have two options. No, they did not. But then they retained the 10-day given to that committee and said they're using that for the plenary investigations. What do you have? You have a sham of a trial. And in trying to punish the man, Rigathi Gachagua, in that way, the Senate and the National Assembly demeaned his office. They demeaned the office while trying to punish the man. And in demeaning the office, they, my Lord, grossly violated the Constitution. My Lord, thank you for the opportunity to address you.
I think we have made good progress with adjourn for lunch, then we come back at 7:32.
That's right.
Thank you so much. You brought that argument. You brought that argument yesterday, I did buy it fast. Yeah? But after a while, it began making a lot of sense.